Thanks, Gancola.
You have 13 minutes, Deputy.
Okay. This bill seeks to amend the Residential Tenancies Act of 2004 and 2009 and the Housing Miscellaneous Provisions Act of 2009. Its objective is to streamline and simplify those acts and reduce delays in the dispute resolution service of the Private Residential Tenancies Board. The bill makes provision for the inclusion within the remit of the Residential Tenancies Act of tenancies in the voluntary and cooperative housing sector. The issue of rent arrears and deposit retention are not addressed in the bill as published, but the Minister for State has signalled her intention to include these at a later stage in the legislative process, and I warmly welcome this initiative. In their recent 2011 annual report, Threshold state that they dealt with over 3,000 cases involving the retention of deposits in that year. Deposits may only be retained by landlords in limited circumstances, namely rent arrears, outstanding utility bills, or damage to the property above the normal wear and tear. The programme for government contains a commitment to introduce a rent deposit scheme, and legislation is currently before the Dáil to follow through on this important policy goal. The Minister for State has signalled her intention to examine the findings of a PRTB Commission report into the viability of a deposit protection scheme. That report has been published at this stage, and the report examines the options for a deposit retention scheme. I believe over the coming weeks the options in the report will consider the best way to offer the greatest protection to tenants in this area. This will be done at the least cost to the Exchequer. There are complex issues, but to deliver on deposit protection in the context of the current bill is very important. Deposit protection schemes exist in a number of countries such as England, Wales and New Zealand, and in these DP schemes the deposit is paid directly to a third party and retained until the end of the tenancy. This bill will amend certain provisions of the Residential Tenancies Act which govern the private rental sector as well as the Private Residential Tenancies Board. One of the PRTB's most important functions is the provision of a dispute resolution service which mediates between landlords in tenants outside of the court system. The largest category of cases referred by landlords to the PRTB relate to rent arrears, which is 31% in 2010, while most of the cases referred by tenants relate to the deposit retention, which is 72% of cases in 2010. Decisions made to the dispute resolution service are legally binding. Increasing demands have been placed on the dispute resolution service in recent years. This has resulted in determination orders taking as long as 8 months to be concluded. Two of the bill's aims are to speed up the dispute resolution service provided by the PRTB and to bring the voluntary and cooperative housing sector under the governance of the Rental Tenancies Act of 2004. A study carried out in 2011 by the Housing Agency looked at the implications of bringing the voluntary and cooperative housing sector under the remit of the PRTB. The report identified two potential issues: an increase in the workload of the PRTB, as well as the affordability of paying registration fees for the approved housing bodies. It is also intended that the Minister for State will address the issue of non-payment of rent by tenants who remain in situ. This, I understand, will be addressed at the committee stage of the bill. The PRTB was established in September 2004. One of its main functions is, when called upon, to mediate disagreements between landlords and tenants. When a landlord takes on a new tenant, they must by law register the tenancy with the PRTB and include the names and details of the tenant. The landlord pays the PRTB a fee per tenancy. There is, I believe, a level of non-compliance in this area which must be addressed, and I would ask the Minister to consider this. The most common complaints made by tenants are refusals of landlords to refund the deposits. 72% of all cases taken by tenants, and indeed, as public representatives, we know this to be true. The most common landlord complaints, of course, are rent arrears and breach of other tenancy obligations. 68% of all cases taken by landlords were regarding these matters. Orders made by the PRTB are legally binding. If a landlord or tenant is dissatisfied with the decision of the board, then legal recourse to the High Court is permitted only on a point of law. Initially, the PRTB was funded by the Exchequer, but it has been self-financing since 2010. From February 2009, properties for rent must meet minimum physical standards as outlined in the Housing Standard for Rented Houses Regulation of 2008. Each individual local authority decides on its enforcement strategy and inspection arrangements. The PRTB is currently entitled to retain 80% of the registration fee to fund its activities, with 20% of the fee going to local authority for inspections of private rental accommodation. The Coolock-based Northside Community Law Centre in its recent submission states that quite often the quality of housing in the private rented sector is poor. They quote threshold in saying that up to 78% of private rented property is substandard. The PRTB should interface more effectively with local authorities in enforcing standards and inspections by many local authorities. Their inspections are slow. If adequate resourcing is not provided, particularly in light of an increased workload, this issue will continue to be a significant problem. The number of inspections carried out by local authorities has been increasing in recent years. However, concern has been expressed as to the outcome of the inspection process and how effectively it protects tenants. In my experience, local authorities do not use all of the 20% of the PRTB fees they receive for inspections, but instead use it for general housing expenditure. And in my view, they only carry out inspections when particular private dwellings are brought to their attention. I believe this has to change, and a better system of inspections needs to be put in place by local authorities, and in particular to inspect the older stock of private rented dwellings, much of which is substandard. And I would ask the Minister to look at this. The demand for the dispute resolution services of the PRTB has increased, while the staff numbers working in the PRTB has been reduced. The 2010 annual report of the PRTB published stated that 2010 was a very challenging year for the Disputes Resolution Service, with an unprecedented 2,230 dispute applications being received, representing an increase of 20% over the 2009 figure. The report goes on to state that most of this increase was due to rent arrears complaints from landlords against tenants. However, it also stated that deposit retention remains the largest overall cause of disputes. In 2010, 59% of applications for dispute resolution were from tenants, 37% from landlords and 4% from third parties. From 2009 to 2010, there was a 93% increase in tribunal hearings. Despite the increase, waiting times for a tribunal hearing have been reduced from 6 to 8 months in 2007 to 2 to 3 months in 2009 and 2010. This legislation, will further improve our system of tenant-landlord regulation. The measures that promote mediation in dispute resolution are particularly welcome. I firmly believe that mediation can give people in a dispute a speedy, efficient way to resolve the issues. The extension of the registration requirement to a large number of voluntary housing tenancies is also a major development. It is the first step in a process that will see statutory regulation of the voluntary and cooperative housing sector in the coming years. This will bring greater transparency and accountability to this important sector that is playing an increasingly active role in social housing provision. Some provisions of this bill aim to speed up the dispute resolution service. Settling disputes through conference calls may not be permissible in future. Housing associations are non-profit organisations which provide housing for those who are in need and at affordable rent levels. In general, they are companies limited by guarantee without a share capital. Approved status is given by the Minister under Section 6 of the Housing Miscellaneous Provisions Act of 1992. While voluntary and cooperative housing is considered as one sector, there are important distinctions between the two. Voluntary housing is provided by non-profit organisations, whereas housing cooperatives are self-help and jointly owned member-user associations or societies. The members share responsibility for their co-op and are represented in the management committees or boards of directors of these companies. The AHBs are not covered under the Rental Tenancies Act. This means that tenants do not have the same rights as private sector tenants, and their landlords do not have access to the PRTB. If there is a dispute, the only avenue open to landlord or tenant are the courts, which may be costly. This can be particularly difficult for social housing tenants, many of whom are in receipt of social welfare benefits only. One of the most significant aspects of the bill before us, Corley, is the inclusion of dwellings let by approved agencies within the remit of the Residential Tenancies Act. This will extend to the large majority of not-for-profit housing sector the same range of tenant and landlord rights and obligations as pertain in the private rented sector. I want to commend Minister for Housing, Jan O'Sullivan, for the hard work she is doing in this area and also for the excellent work done by Threshold in terms of housing rights for the less well-off. I look forward to engaging with them on the housing reform agenda over the course of 2013. Thank you, Corley.
Thank you, Deputy. I now call on